Alright, in response to the claim that exclusionary rule lets criminals that have committed big crimes get away, I'm going to quote attorney and author Albert Althusser in his article in University of Chicago Law Review 2008. He states, federal courts excluded unlawfully seized evidence in only 1.3% of all criminal cases filed by federal prosecutors, and search and seizure motions were successfully in only 0.7% of all criminal cases in a large 9-county state court sample. Moreover, federal prosecutors refused to prosecute only 0.2% of the cases in which felony arrests had been made on the ground that they feared the exclusion of seized evidence, and in California only 0.8% of all arrests were rejected for prosecution because the prosecutors anticipated the suppression of evidence. And also, as a professor of humanities in Thurman Graduate College, Leonard Levy states in his article, when a charge is murder, rape, assault, or robbery, prosecutors decide not to proceed in 1 out of every 2,500 cases. Only 0.4% of all cases that federal prosecutors decide not to prosecute are rejected because of search warrants. And if the exclusionary rule were abolished, the conviction rate in all felony cases would increase by less than half of 1%. Now, of course, with anything in life, with any decision you make, any law or rule, there's a trade-off. What you need to consider is the value of this trade-off. Exclusionary rule lets very few criminals off free. However, it protects our society and ensures a lawful government. My claim is exclusionary rule ensures a free and lawful society. Now, exclusionary rule is a reason and existence and practice of law. Justice Brandeis put it in more comprehensible form. When he states, in a government of laws, existence of the government will be imperiled if it fails to observe the laws scrupulously. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for law. To add to that, Dalen Oaks, an American attorney, in his publication titled Studying the Exclusionary Rule in Search and Seizure, which was mentioned as the most comprehensive study of the exclusionary rule by Justice Rehnquist, wrote, if constitutional rights are to be anything more than pious pronouncements, then some measurable consequence must be attached to the violation. It would be intolerable if the guarantee against unreasonable search and seizure could be violated without practical consequence. It is likewise imperative to have a practical procedure by which courts can review alleged violations of constitutional rights and articulate the meaning of those rights. What are police officers doing by warrantless search and seizures? They're trampling upon our constitutional rights, Fourth Amendment rights. Now, exclusionary rule encourages the practice of constitution. It allows judges to decide whether citizen rights have been violated based on constitutional rights, which I should suggest we trust a judge to judge actions in society more than we trust police officers. In his article, Dalen Oaks, again, states the advantage of exclusionary rule, entirely apart from any direct deterrent effect, is that it provides an occasion for judicial review and it gives credibility to constitutional guarantees by demonstrating that society will attach serious consequences to the violation of constitutional rights. The exclusionary rule invokes and magnifies the moral and educative force of law. Now, exclusionary rule does not protect criminals. It does not prohibit warrantless searches in all cases. There are exceptions to that. There is a search incident to lawful arrest, which means that a criminal is lawfully arrested, they can search. They can search only the person arrested in the area within which a person might gain possession of a weapon or might destroy or hide evidence. There's a protective sweep search that allows law enforcement officers to search the area immediately around the arrestee, the path, block, or hallway directly to, from him, and the entrance to the residence. And what the exclusionary rule does is to protect innocent citizens who may be victims of the discrimination. It requires warrants for any search and seizure except in cases similar to the ones I mentioned, or by probable cause, which exists when the facts and circumstances within the arresting officer's knowledge are sufficient to warrant a prudent person to believe that a suspect is committing, or is about to commit a crime. That means the police officer has to act as a prudent person. That means sensible, careful. That gets rid of any sensitivity they might have towards a certain race or class. I mentioned, there's also another legal way around the exclusion rule. If the court determines that the evidence obtained in an unlawful search would have been found at a later warranted search, the evidence may be brought forth in the case. There's also, let's see if I can make sure. And the exclusionary rule, the main purpose of the exclusionary rule, I don't think they really focus on it, is to deter police misconduct towards all citizens. Some may be criminals, some may be innocent, but the importance is that we act upon the Constitution that founded this country and the government. If the government breaks the law, then the government is the criminal, and that's hypocritical.